My name is Cara Drynan. I'm a professor at Catholic and also the director of faculty research. It is my pleasure to kick off the summer with tonight's discussion. I just wanted to briefly mention how these kinds of discussions came about, and that is that last summer, as the pandemic was sort of taking over the world, and as we were all accepting that new reality, there were so many legal questions coming up that were triggered by the pandemic. Issues of the criminal justice system being impacted by COVID, and elder care, and small business administration, and intellectual property. And so faculty at the law school realized this was a unique opportunity to connect with alumni in those various fields to discuss really rapidly evolving developments in the law. And so because that was such a popular series last summer, we've decided to continue that discussion series. Thankfully, we're moving out of a pandemic, hopefully. Thank you, science. But as I said, it's been really exciting for our community to be able to connect this way. So I am pleased to say that tonight is the first of the 2021 summer discussion series, as you know, entitled Recent Changes in Immigration Policy, Impact on the Border and Beyond. And I'm going to turn it over to my colleague, Stacey Bruston. Let me just briefly introduce her. I won't take too much time. Stacey has a super impressive CV that I will not take a lot of time to discuss, but I will simply say that Stacey, Professor Bruston, is a professor of law at Catholic University and also the director of our Immigration and Refugee Advocacy Clinic. She not only supports students in litigation and advocacy in the immigration and refugee arena in Virginia and DC, but also teaches in clinical education and has herself been pursuing an interest in immigrant and refugee issues for most of her practice, her career as a practitioner. Stacey is an expert not only in immigration and refugee advocacy, but also in domestic relations, access to counsel, and professional responsibility issues. Her clinic has been hugely popular, and it's obviously providing a really critical service at this moment in time. So with that, I will turn things over to Professor Bruston.
Thank you. Thanks, Cara. And thank you all for being here tonight. We're very excited to welcome several of our illustrious alums who are in the trenches, in the field, practicing to help us get a better understanding of some of the changes that have been coming down the pike over the last several months. You know, it seems as though almost every day we're getting reports about new changes to immigration policy. The Biden administration is reversing many of the policy and legal changes implemented during the Trump administration, leaving immigrants and lawyers alike struggling to keep up with the current state of affairs and the consequences of those changes. I think you've probably, many of you, not all of you are practicing in this area, but I'm sure you've heard some of these terms in the news, things like the migrant protection protocols, known commonly as Remain in Mexico, was recently terminated. That program, which required asylum seekers trying to cross the southern border to remain in Mexico to pursue their asylum proceedings. There's a phase in now of individuals being allowed to cross. Those protocols don't apply to children. So there are, we're kind of in a state of flux about what's happening there. The Title 42, which was a public health law that was used essentially to close the border as a result of the COVID pandemic. That is still in place, although it does not apply to unaccompanied children. And so there are consequences of that. There have been changes in enforcement priorities. Who is to be detained? Is there, there's now a new hierarchy and a lot of questions about how that's being implemented. Temporary protected status was recently adopted for Venezuelans and individuals from Myanmar. There have been TPS that's been redesignated for Haiti, which some of our guests are going to talk a little bit about, and the impact that that's having. And then most recently, just a few days ago, there was a major change in asylum law with the overturning of some Board of Immigration Appeals decisions that had previously been overturned in the last administration. So today's panel is going to focus on the impact of these shifts and changes on the ground, particularly on the immigrant clients that our speakers serve day in and day out. So today we're going to be hearing from Madeline Taylor Diaz. Madeline is a 2013 alum of the law school, and she's a supervising attorney at IUTA, a legal and social services agency serving the DC, Maryland, and Virginia immigrant and refugee communities. Madeline is with IUTA's Virginia Immigration Program, and she's also the manager of their children's program, where she represents immigrants in humanitarian and family-based immigration cases. After law school, especially, I want to put a special plug out there to the law students who I know, some of you are in my clinic, who are watching, that Madeline, after she graduated, joined IUTA as an Equal Justice Works legal fellow to work on children's immigration issues, which is a wonderful, I think, a wonderful kudo for the law school and a great way for her to launch into an immigration career. And as you probably can tell from her title, her practice focuses largely on the representation of non-detained unaccompanied minors. And that's the main issue she's going to be discussing, as well as some of these changes in asylum law. Joe Cano is our second speaker. He's a 2013 alum who currently is living and practicing in Miami, Florida. Joe is a staff attorney at Catholic Charities Legal Services for the Archdiocese of Miami, where his practice focuses on representation primarily of non-detained adults. And he has worked in several areas of immigration law, including asylum, immigration relief for Cuban immigrants in particular in Miami, and recently on temporary protected status. And he's going to be discussing that, as well as some of his work with the homeless community in Florida, and some of these what he calls adjacent needs of clients that are sort of indirect issues that clients are facing that can have a huge impact on their immigration status, and that interrelationship between immigration issues and other legal issues or non-legal issues that are affecting client populations. And then finally, we have Cathie Dunn, who is a 1991 alum, and Cathie is the executive director of the Capital Area Immigrant Rights Coalition, or the CARE Coalition. And Cathie has served as CARE's executive director since 2008. And during her tenure, the organization has expanded from a staff of 6 to a staff of 65, or maybe now it's even more than that, Cathie, right? It's probably more. And they've added several new programs, the Detained Children's Program, the Immigration Impact Lab. And prior to joining CARE, Cathie was the deputy director of the Central American Resource Center, CARECEN, in Washington. And the CARE Coalition and Cathie's work is primarily on behalf of detained immigrants, adults and children. And so she's going to discuss the current realities for her client population. And so we're going to hear from each speaker, and then we'll have time for questions from the audience and hopefully some conversation among our speakers. And before I turn it over to Madeline, I do want to just say that proudly that all 3 of our speakers are alums of Columbus Community Legal Services, our clinical program at Catholic University. And we have at the law school one of the oldest in-house clinical programs. I've had the privilege of teaching there for 25 years, and I'm excited to see our former director of many, many years, Ellen Scully, who's here, and was on our faculty for many years. So anyway, I'm very excited that all 3 have been able to participate and do the clinic proud. So with that, I'll turn it over to Madeline.
Sure, thanks so much for that lovely introduction. I'm thrilled to be here. Actually, when I was in the clinic, I did my very first U visa case. I thought I could start with that. one major change that I've seen in the clients that I work with are some changes in the administration as of recent regarding the U visa. So the U visa is a form of immigration relief which exists as more or less as a law enforcement tool to protect immigrants who've been the victims of a certain set of crimes. At the work that I do at the nonprofit where I am, we represent a lot of domestic violence victims who are submitting applications for a U visa after having cooperated with law enforcement to report their abuser in a domestic violence case. Unfortunately, one of the biggest drawbacks to the U visa is that there is a statutory cap of 10,000. And this is something that advocates in my field have been thinking about a great deal, and there's been advocacy on the Hill and lots of thought, federal litigation about how to address that statutory cap, because we, as of last year, and really in the last couple of months, have been telling people if they submit an application for a U visa based on having been the victim of one of these qualifying crimes, that they might be waiting for 12 years in order to receive that status. So not only is just that wait time pretty crazy, but it also means family separation. If they were including family in home country, it means that their family wouldn't be able to come and join them until the adjudication of that U visa in 10 to 12 years. And the wait list grows every year as more and more applications roll in. So some of the changes that we've seen recently in U visas are first, the determination that individuals who present a bona fide case with a good merits and appear to be prima facie eligible for a U visa are able to get employment authorization during the wait. So this is huge because previously there was an option to get employment authorization a little bit sooner than the case was adjudicated, but certainly not for many, many years. And hopefully that will change. It's to be determined how it rolls out and how those adjudications take place, but hopefully it will mean that immigrants who are participating in this program and applied for the U visa won't have to wait 10 to 12 years before they can lawfully get employment. So that's one thing I'm really excited about as a recent change that will certainly affect my population of clients. Second of all, another change to the U visa program has been addressing that question of family separation. Because you can't bring any derivatives or family members that you're including on your application until it's decided, there was an announcement that certain family members, Central America, and this applies in Central American countries, certain family members of people who are waiting for their U visas, their final U visas, can come to the United States and enter on something that's called parole, which is a temporary status to be reunited with their family during that long wait. I think that lots of advocates continue to make noise about the 10,000 statutory cap, but these are two really positive changes that we've seen in the last couple of weeks that will help domestic violence victims and other victims of crime that are applying for this form of immigration relief. So that's the first one I thought I would highlight. And I think that's sort of really down in the weeds. So it may not have made a lot of news as opposed to the other change that I wanted to talk about and raise, which is some changes to the asylum program and that form of immigration relief. In the previous administration, there were two pretty big deal cases that came out, which impacted the eligibility of certain categories of individuals for asylum. And I think it was last week, although it's all kind of a blur now, there was an announcement by the current AG that he was Merrick Garland, that he was overturning two presidential cases from the previous administration that affect asylum. So these decisions recognize that there were errors in the cases of the matter of AB and matter of LEA is what they're called, and should hopefully strengthen the ability of adjudicators to grant asylum to individuals that are fleeing gender and family-based persecution in their country of origin. And also more generally to people that are fleeing violence by non-state actors or private actors. And it restored, particularly in relation to asylum cases related to DV, it restored precedent from, I guess it was from 2014, that provides a framework for determining asylum eligibility for certain survivors of domestic violence. This is also going to hugely impact the work that I do, because at AUTHA we represent a great deal of individuals who are fleeing Central American countries because of persecution related to domestic violence or asylum based or seeking asylum based on gang violence by non-state actors. And so I anticipate that we're going to see an increase, hopefully, in approvals in those case types. So those are the changes I wanted to get us started with, and that will certainly impact my work and my clients.
Thank you. And Madeline, can I just ask you, just before we move on, just so everybody's on the same page, there might be some confusion for folks who aren't as familiar with immigration law as to how the Attorney General of the US can overturn these cases that are now precedent for immigration courts. Do you want to just mention why that's the case, unlike, most other areas of law?
Yeah, I can give it a go. Maybe I should have paid more attention in admin law, but in immigration, as it's an administrative form of law, there's an ability for the Attorney General to do what's called certifying cases to himself, or herself. And when the cases are certified to the Attorney General, they can issue precedential decisions at that BIA level, which is sort of the first appeals court level in asylum proceedings and people that are facing immigration proceedings or removal. And so some cases make their way up naturally through process of appeals, but then in these two decisions, and then also their counterparts previously in the last administration, the way that it worked is that the Attorney General would certify cases to himself and would issue a written decision, which would impact the BIA level of law. And so there's, of course, the circuit courts above the BIA. That's the next appellate level where we would go. And so there's oftentimes some those might conflict, but the BIA law is hugely important in immigration practice and individuals facing removal throughout the country. So,
thank you, and I'm sorry I didn't mean to make it by making you feel like I had just called on you.
It's okay. I think I handled it okay.
But yes, very well. But I also think it's important to know that all the immigration courts fall under the Department of Justice, so they're not Article 1 or Article 3 courts, like many of the courts we're familiar with. So at that top of that hierarchy under the Department of Justice would be the Attorney General who has this authority. So okay, well, thank you very much. We'll get back to you. I'm sure there are going to be some follow-up questions about U visas and asylum changes. Joe, do you want to jump in here?
Sure. Okay, well, my name is Joe Cano. I'm at Catholic Legal Services down in Miami. A couple of things I wanted to talk to everybody about today are the recent changes in TPS and sort of some of the issues that homeless people face who do not have status. We have somewhat of a unique population down here in Miami. So starting first with TPS, or temporary protected status. Temporary protected status is a statutory permission given to the president to designate certain countries, nationals from those countries here in the United States, to receive a protected status for about 18 months. It doesn't mean you can't be ordered removed. It means you can't be physically removed. Okay. It also gives you the opportunity to apply for a work permit and to have a driver's license and to have the peace of mind that you need and that you're not going to get arrested and deported by ICE. Here in Miami, we have two big populations that are affected by TPS. And if I'm not mistaken, the last time TPS was granted, I believe, was in 2010 for the Haitian community after the earthquake. President Biden's administration has recently designated Venezuela and Haiti for TPS, which are huge for the South Florida community. There are a lot of Venezuelans and a lot of Haitians, and they're very different populations. The Venezuelan population here tend to be from higher socioeconomic classes. It's a different political scenario about whether or not they can return. The Haitian population here is quite large. I think it might even be larger than the Venezuelan population. And for both countries, it's huge. For the Haitian population, or for Haitian TPS rather, they actually haven't designated in the Federal Register yet the registration date. So once the president announces that a country is going to receive TPS, then afterwards they have to announce a registration, 6-month registration period, wherein anybody in the United States who was present before a particular day, so for Venezuelans, it's before March 8th. Professor Bruston, feel free to let me know when I've got a minute or 2 minutes, or I've been talking for too long. But anyways, anybody from Venezuela who was physically here before March 8th can qualify for TPS if you don't have a conviction for 2 or more misdemeanors or for 1 felony. Okay, so that helps a lot of people. They also have to not have been firmly resettled in another country. A lot of our Venezuelan population actually have dual citizenship with Italy or with Spain, so it can be a little bit challenging. For the Haitian population, they have not designated that date yet, and unfortunately, we're finding a lot of notarios or sort of predatory non-lawyers starting to fill and even file applications for our Haitian community when it's not even time yet. And so there's been a big push on our office to let the Haitian community know, hold on, please don't fill out your TPS applications. Do not send them to the place where TPS renewal applications are sent for people who already have TPS. So that's sort of the campaign we're running right now, is for everybody to slow down so that we can submit these applications appropriately. Another issue with TPS right now, and that's big, and we're really hoping and praying down here too that we see TPS maybe for Honduras. I mean, that would be amazing, or for Nicaragua. We're hearing rumors that maybe this will happen, but of course, we don't know. We don't know. Although that would be very big. There's a whole other question about how this affects people who are in removal proceedings. If they're currently in deportation proceedings, whether or not receiving TPS is going to lead to something we call administrative closure, which is when your immigration case is simply paused. Although the previous administration took administrative closure away, so we don't know what's going to happen there. So that's one side. Oh, another big development with TPS recently is that the Supreme Court recently said that receiving TPS is not a legal admission. In order to get your residency in the United States, let's assume you have a family member that can apply for you, like a U.S. citizen child over 21 or a citizen spouse. You have to have had a legal admission into the United States in order to be able to get your residency from the United States and not have to leave the country, which can bring all these other complications about whether or not you can get back in. There's all these penalties if you leave the country to go get your residency abroad. We were hoping, even though the 11th Circuit down here in Miami was not one of them, there was a circuit split about whether or not the grant of a TPS was considered to be a lawful admission for somebody we call EB, entry without inspection, somebody who's entered from the border and has never had like a visa entry or a parole, which is another kind of entry. Unfortunately, the Supreme Court said that it is not a lawful admission. So that's causing a lot of complications for us. USCIS is also not considering advanced parole to be an admission, but that's another topic. The other big thing that's sort of unique, I think, to South Florida is our work with the Cuban population. Starting in the 1980s, we received South Florida received a huge influx of Cuban people. It goes back to the 60s. But in 1980, about, I want to say 150,000 people came through the Mariel boat lifts to the United States. A lot of those people became inadmissible, which means they can never get residency status based on a drug conviction. A lot of these people, doors are slowly closing more and more and more to a lot of this population. And there's a lot of reasons for that. In 1996, there was a change in the law regarding, and this is something, for lack of a better term, is immigration adjacent. It's not specifically immigration, but your immigration status affects whether or not you can qualify for public benefits. And a huge one that I don't think gets enough attention is the Real ID Act, which is just devastating a lot of our homeless people down here. The Real ID Act, and go look it up. 6 CFR 37.11 is not my favorite reg. It says in order to get an ID now, now that states are issuing Real ID compliant driver's licenses, you have to present a passport with a visa and a 994. And if you don't know what a 994 is, it's the record you receive. It's now digital, but it's the record you receive when you come into the country legally. Well, that means that tons of people down here in Florida, and I imagine a lot of other states, can no longer get an ID. And especially if you're homeless, this has just been devastating to a lot of our older homeless population who will never qualify for residency. They may be on some sort of deported status called an order of supervision. Cuba literally won't take them back. Even though deportations theoretically started back in 2017, Cuba has discretion to not accept the planes from ICE bringing people in. In fact, our organization with some other groups down here in Florida just did a FOIA from the State Department to figure out, well, how is Cuba making these determinations? And basically it's just discretionary. So Cuba won't take somebody who's been here for 30 years, who maybe has drug convictions. And now that person can't get an ID. So maybe their disability is getting deposited into a bank account, but they can't withdraw that disability because of their ID. They can't, there's a million things you don't realize you use your ID for on a daily basis that now that they don't have, they're not able to access. Even just getting the sort of reduced rate bus card down here in Miami, you can't do it without an ID. Also, Cuba doesn't give a lot of their older citizens passports, and there's only authorized vendors of Cuban passports, and those cost $500. So the Real ID Act, we're hoping that Florida will one day issue non-Real ID Act compliant IDs. Recently, the mayor of Miami-Dade County approved, along with the commission down here of Dade County, for community IDs. Those haven't come out yet, and we don't know how effective those are going to be for people wanting to use them in various different contexts. So,
Thank you very much, Joe. All right, and now let's turn to Cathie Dunn.
Sure. Thank you, Stacy. First, I wanted to give a shout out to Professor Scully. She was my clinical professor, and it was when the clinic was down on North Capitol Street in a row house, and it was a lot of fun. So yeah, I think I'm going to draw the lens back a little bit further, and then talk about one specific change. And a couple of things. One, you've already gotten a sense of how complicated immigration law is, and just how, little things like a lack of ID can just escalate and cause incredible problems. And so I think it's important to remember that there is no right to counsel in immigration court proceedings. There is no right to counsel for detained immigrants. There's no right to counsel for immigrants who couldn't otherwise afford to have representation in immigration court, because immigration law is civil in nature. And so, we've had clients who have spent years in detention, but have no right to counsel, but for the fact that they were detained in a immigration facility that's within the jurisdiction of Care Coalition, they were able to get legal assistance. But even with that, and with all of our efforts, only about 10% of the adults who were detained in the detention centers in the DMV have representation. And so I think that's important to remember. Immigration law is complex, in many ways is counterintuitive, and I'm going to talk about a piece that is counterintuitive in a minute. and then all these changes coming down. So while there may be good changes and good things that are happening, and the matter of AB was huge, if you do not have a lawyer to help you navigate this, it might as well just not have happened. So, so that is, I think, an important piece to remember. So as Stacy mentioned, Care Coalition, we are the only legal service provider that has a program in the DMV, DC, Maryland, Virginia area focused exclusively on detained immigrants. So we serve detained adults, any arriving asylum seekers to long-term residents. We work with unaccompanied immigrant children who are initially detained on the border and then are placed in facilities in our area. We also have what we call our Immigration Impact Lab and have done a lot of impact litigation. And for those of you who have been in this space for a couple of years, at least for the last 4 years, basically litigation was the only tool in the toolbox to try to move policies forward. I would say for us, one of the biggest positive changes is the new enforcement priorities. So the enforcement, and actually technically they're interim enforcement priorities. So basically this says, who ICE is going to prioritize to detain. And essentially under the last administration, it was, there basically were no priorities. If you were not here on some sort of legal status, you were subject to arrest, detention, and deportation. So there were a large category of folks who under the Obama administration had been checking in regularly, had maybe final deport orders, but those were not being enforced. And so they were checking in regularly, sometimes for years. And all of a sudden, those folks were subject, they were being picked up, sort of anybody and everybody. So it was a welcome change that those detention priorities or enforcement priorities have been narrowed. And basically there are 3 right now. And there was something issued just a couple of weeks ago, further providing some clarification for these new enforcement priorities. So the 3 current priorities are: 1, individuals who pose a national security risk; 2, recent arrivals. So anybody who's arrived, I think it was as of November 1st, 2020, adults and children are enforcement priorities. And then 3, threats to public safety. So threats to public safety include anybody who has a conviction for an aggravated felony under the INA, Immigration and Nationality Act. So if you're sitting there thinking, well, what's so bad about that? Aggravated felons, it sounds pretty terrible. But again, this is where the counterintuitive part comes in. So under the INA, an aggravated felony does not necessarily have to be a felony, nor does it have to be anything violent. So under the INA, Immigration and Nationality Act, an aggravated felony is defined as any crime for which you could have received at least a year in jail. So what you were ultimately sentenced to doesn't matter. And so for example, in Maryland, if you shoplift something that costs more than $100, you are subject to a penalty of up to 18 months in jail. It is a misdemeanor under Maryland law, but under the Immigration and Nationality Act, that's an aggravated felony. So if you pled guilty, got community service, right? Because it was a first-time offense, you shoplifted, I don't know, $200 something, never served a day in jail, you are subject to being detained and subject to arrest, detention, and deportation. And because you've been convicted of an aggravated felony, you're also not eligible for bond. So this is an area where, again, that counterintuitive, because I think when people think, oh, aggravated felon, you must have really done something terrible. You don't have to have done something terrible. And so while these are really, it's a step in the right direction, and not to be negative, but while there have been a lot of good changes, fundamentally, the system has not changed, right? Fundamentally, the structure of laws in which people can be subject to arrest, detention, and removal has fundamentally not changed. There was, for those of you who've been around long enough, a law passed in 1996 that basically did two things. It took away discretion from judges to weigh the good and the bad, and it greatly expanded the grounds on which you could be deported. So short of a comprehensive immigration reform would change that, would change the definition of aggravated felon, there are a lot of people who potentially can still be caught up in that net. But as I said, step in the right direction. Another part of the enforcement priorities memo that recently came back was an emphasis on prosecutorial discretion. And prosecutorial discretion in the immigration context can basically use anywhere along the way, right? It starts with whether ICE decides to detain you or not, right? They have the discretion not to. They can make a different decision. They can decide that they will join in a motion to administratively close your case because you have some other benefit pending, and it's going to take a while to approve, so we're just going to close your case now. They have discretion not to enforce a deportation order. And so what this new enforcement priority memo said is it actually includes an obligation on the part of the government, attorneys, to review their caseload to see if there are folks who might potentially be eligible for prosecutorial discretion. It also gives advocates a new tool in the toolbox, right? Because before you could ask for prosecutorial discretion, you most likely were not going to get it. But now that door may be open again. And so that is a great tool because short of comprehensive immigration reform, there are a lot of folks who are still going to be subject to detention and removal until such time as the law changes, provides a pathway to citizenship, even for people who've been here for many years. So prosecutorial discretion is a good tool to have in the toolbox. Now, a caveat to that is that under the recent memo, a lot of discretion is basically inures to the local attorneys. It's the OPLA, the Office of the Principal Legal Advisor. For those of you who are keeping track of all the acronyms we're using, OPLA, Office of Principal Legal Advisor. So every local jurisdiction will have their own local attorneys. And so the memo gives them a lot of discretion. So the jury is still out, at least in my office, as to whether this is, how this is actually going to be enforced on the local level. But again, to the extent that those at the top are telegraphing that this is something you should be aware of, you should be using, it helps those of us on the ground to say, hey, you guys really need to look at this. So that is good. What has really, so the detention population is down nationwide, principally because of COVID. And while ICE did drag their feet there for a bit, there have been released people. There's been a lot of advocacy around that. However, we're actually beginning to see detention creeping up again. We just at Care Coalition, there were 30 folks who were flown in from the border who are now in one of our detention facilities. And for those of you who don't know, there's essentially mandatory detention of asylum seekers. And so you can ask to be released, but the government doesn't have to. And so it sort of remains to be seen as things open up at the border, whether people are actually going to, be released or whether they're going to be held in detention pending their immigration court proceedings. But again, this memo is important. And so hopefully it will lead to less people having to wait in detention while their immigration hearing is taking place, which, another side note, can now be years, because one of the other parts of the system, in addition to the laws, is essentially the immigration court system is in many ways collapsing under its own weight. There's something like 200,000 plus pending cases. So if you are a non-detained asylum seeker, yay, but you may not have your court hearing for 3, 4, or 5 years. So that means you may have family members in home country who are in hiding, waiting for you to get granted asylum so they can come here. So again, just pieces of, the system in many ways faces a lot of challenges despite these changes, which are good. One final thing, and then I'm probably getting up toward my time, is we've talked about some really good things. I do want to raise some concerning policy that we're seeing and the advocate community is pushing back on, and that is the Biden administration has basically proposed restoring what colloquially referred to as the rocket docket for families who are arriving at the border and seeking asylum. The Trump administration instituted or tried to institute a similar rocket docket. It just wreaked havoc with anybody's due process rights. And so the Biden administration recently, with little notice to the advocate community back in May, announced that 10 cities would be a pilot for the rocket docket. So these would be families who would be let in, again, good. They would be placed on what is called alternative to detention, which is essentially an ankle bracelet, better than being detained. But they would essentially be placed on this accelerated docket, and so would be in court very quickly. When the administration did this, there was no discussion with the local nonprofits as to whether they had capacity. They don't. And so there has been pushback. There was a letter that was sent to the administration signed by 160 nonprofits saying, hey, wait, whoa, this really is not going to work. These families, these individuals have a right to due process. We've just heard a little bit about how complex matter of AB, has been overturned, but, people need to figure out what that means. A lot of these families, female-headed, fleeing domestic violence, could really benefit from AB. But if you don't have a lawyer, then that isn't going to help you. So again, few steps forward, but there's a long way to go before it is truly a fair and just system where everybody gets their due process.
Thank you. All right, well, I want to make sure we have some time if we have questions from those of you joining us. And if not, I have also several questions that have been raised, by the different policies that our guests have talked about, that our speakers have talked about. And Professor Drinan is going to be helping me here with questions.
Yes,
any questions?
I will monitor the chat. And also, I was just about to say, Nikita, thank you for putting your hand up. I was about to say you can also use your digital hand raising. So maybe Nikita, would you like to get us started?
Hi, yes, I had a question for Cathie about just Care Coalition having litigation work around the right to counsel and like how that process has been, and just in general, like the past few years or what still needs to be worked on in terms of trying to get that number up of like 10%. I was just curious, how has that been?
Sure, great question. Interestingly enough, I actually wrote my law review article on the right to counsel. And basically the bottom line is that except for some very limited exceptions, because it is a civil proceeding, there is no right to counsel under the US Constitution. And so unfortunately, that is just a reality in terms of, litigating on that. However, what the advocacy community has done in the last couple of years is really tried to expand access to counsel. And so there is an effort underway that really the goal is universal representation for every individual in removal proceedings, both detained and not detained, so a federal public defender system. So there are pilot projects probably in about 20 cities so far. There are 2 states, actually, New York and California, that have put up funding enough funding to represent all of their citizens in detention and removal proceedings. In this area, DC, Prince George's County, Fairfax County, and Baltimore City are all jurisdictions that have put up money in order to partner with a legal service provider. So they pay a legal service provider to represent their constituents. Right now, it's focused on people who are in detention, but it has made a significant difference, and that has helped us gin up our numbers. And there is a big push to continue that effort. One interesting fact is that although detentions were up over 40% under the Trump administration, there were actually fewer people deported than under the Obama administration. And the main reason for that was the growth in the immigration legal service provider community and the growth in universal representation efforts statewide. So stay tuned, Maryland. We tried to get something through this, didn't work, but we'll keep at it. But that is what is seen as a viable alternative, lacking a constitutional right to counsel in immigration proceedings.
And Madeline, I don't know if you or Joe, if you want to add anything. I know there's also, you know, there are some improvements in terms of representation for minors.
Yeah. Cathie and our organizations actually both have a part of our funding for detained children is under a universal rep model. And so it's of course funded through a foundation, but there's some pass-through money from the Office of Refugee Resettlements, which funds the work to represent all detained children. And so I think, you know, that's one of the limited areas that Cathie was mentioning. And then there is this very small program for the appointment of what they call qualified representatives or attorneys for individuals who've been found to be incompetent by an immigration judge or lacking the capacity to represent themselves if they're undetained. So those are two sort of small carve outs to a right to counsel that do exist. But I would agree with Cathie that I think the just increased funding for nonprofits and organizations that are representing immigrants on the ground is really the way to assure a higher level of representation for people facing removal.
Yeah, I'd say all the same things. The only other thing that we're hearing is the immigration court has an office called OLAP, not to be confused with OPLA, called the Office of Legal Access Programs. They have various programs, and one of them is ICH, or Immigration Court Help Desk. And we're hearing that maybe they'll expand funding for that so that we can have more people. Basically, it just pays local nonprofit lawyers to sort of, at least here in Miami, was to camp out in one of the empty courtrooms and to just sort of answer questions, not give legal advice to anybody who walked in, do changes of address and stuff like that. So that may be expanding as well. We don't know.
I had a question, unless I see another one pop up in the chat. And I know you had some too, Stacy, but I was just wondering if, and I don't know which of the three of you might want to address this, but I'm wondering how you find your clients or how your clients find you. And I was especially thinking of that question, Joe, while you were talking, because, you know, you're describing such a hugely vulnerable population, you know, older in age, homeless, and also sounds like being preyed upon by a group of individuals who are not going to help them. So I'm wondering, when you talked a little bit, for example, about your outreach, maybe all of you could say something about how you pair up with your clients to represent them.
So at least for Catholic Legal Services in Miami, one of the big things is that, and I imagine everybody here is on the list that people are given when they go to the immigration court. There's a pro bono or a nonprofit list that everybody's given. So a lot of people come to us through that. With the homeless population, before COVID ended, we were going to the local shelters. For TPS, we've been going to the local Haitian churches. The Venezuelan population has been a little bit harder to access, but the Haitian community is a tighter community, and going to local churches and community centers. Also, I think it's just word of mouth. I mean, the people just come every day. So it's a lot of that too.
All right, so a similar kind of story with Ayuda. It's been around since 1973, and so a lot of it is word of mouth and our clients referring their family members. We also do a lot of work with different law enforcement agencies in the area that are interested in protecting immigrant victims, and they'll refer us their clients, both federal, or pardon, their victims that they might encounter in federal as well as state. And a lot of my clients, since I'm working with a lot of children, are children that are in local foster care who have been identified as being undocumented, or children that come through that enter the United States unaccompanied, or are in custody for a period of time and are released to our area. But it's largely word of mouth. One thing I will say, just it has been a challenge in my practice, is that Cathie was talking about the wait for final individual hearings in immigration court. I mentioned the long wait time for a U visa. Just there's a backlog in just about every area of immigration law right now. It got worse over the pandemic. It got worse over the last administration when there was a lot of changes in policy. So whereas, the cases are sticking around for years and years and years. I've had some of my clients since I started at IUDA in 2013, and I don't anticipate closing their cases anytime soon. So I think that it's so complicated, cases take so long, that the capacity for nonprofit attorneys and any attorney to assist their clients is getting smaller as things change all the time.
I had a related. Oh, I'm sorry. I was just going to say I had kind of a. Go ahead, Cathie, if you want to respond too.
Yeah, no, I was just going to say that our clients, we go to our clients, since we do work exclusively with the detained population, either the facilities where they are holding the children or where they're holding the adults. Now, during the pandemic, we did all of that remotely. But I was also just what Madeline said, again, it's a little thing, right? But can be a huge thing. On a good day, DHS sometimes can have a hard trouble getting the notice of a hearing or the notice involving your case to you. And imagine people having to move, being forced to move because of the pandemic. Again, a small thing, but it can result in somebody ending up with a removal order or being denied an application that they're eligible for.
I was going to ask just a related question, which is, a couple of you have mentioned policies that have caused fear within the community. So the previous enforcement policy that Cathie talked about, where, really people were being detained indiscriminately. There wasn't this prioritization, and that generated a lot of fear. Things like, in the unaccompanied children context, there was a period of time in which the office responsible for housing children was sharing information with the Immigration and Customs Enforcement, the ICE enforcement. So there became a lot of fear that, oh my goodness, if I try to sponsor a child, one of my relatives who's now a child in the country, if I go forward, I could risk deportation. And then Joe talked about the dangers of notarios, of people being preyed upon by individuals who aren't even attorneys. So it seems to me that in order to avail themselves of new and positive policies, people need to have accurate information. And they need to understand where the dangers are, where the dangers might not be. And so what are your organizations doing to get that word out? And do you have other suggestions for, initiatives that are needed to do that? Are you finding that an obstacle? Lack of accurate information or fear?
I don't know how to do this because I don't know anything about technology, but I think somebody needs to try to sort of redominate the YouTube space, because I've got a lot of clients, at least in my populations. I mean, the day after TPS, the TPS case came out, there was another possible major change that affected the Cuban population down here. I mean, clients are hearing, and then you go on YouTube and you see, well, there's all these attorneys giving bad information, and real attorneys, I mean, barred attorneys giving bad information. So I don't know how, cases that are going up for appeal before the Board of Immigration Appeals, and they're saying, well, this is a done deal, so I don't know how to take back that space, but I think it's something that lawyers need to focus on.
Yeah, I would just add, and this is very self-serving, but I think funding for nonprofit organizations is really important, because the most vulnerable among that population, perhaps where the most fear exists, are on low income and undocumented immigrants who are largely seeking legal services from nonprofit organizations. And I think that just expanding the access to counsel through nonprofit organizations that can provide low bono or pro bono services, I think is really important. I know there was a lot of great organizations in the DC metro area, and I'm sure throughout the country, that during the Trump administration and the previous administration, when there was a lot of fear and hysteria, were prioritizing Know Your Rights presentations and just spreading information and giving up-to-date advice and legal counsel. And so I think that efforts to expand access to affordable representation for low-income vulnerable immigrants, I think, is a really important way to sort of help dispel some fears.
I was just going to add to that. I think it's important for whatever community you're working in that you understand who the trusted intermediaries are. So that's going to depend on the community, right? And what method of communication, whether it's working with churches, whether it's working with community groups. At least in my experience in the Latino community, radio is huge. And that's often how people get information. You know, word of mouth, one challenge is also like people know a little bit and, you know, well, my friend said this, and it can really be a challenge. So I do think in terms of, but yeah, more investment in communication that actually reaches the target audience. And for that, you know, whatever works with that particular community, I think is important. And yeah, there are people rushing out to take advantage of folks. And often then we're left to try to undo that damage, but trying to prevent it up front. So yeah, communication is an important facet.
And I'll just jump in and say, I think that's also a particular role that law schools and law students and law school clinics can also help with. I know our clinic and many other immigration-focused clinics are doing Know Your Rights presentations, are partnering with organizations to develop materials. And so hopefully we can contribute as an academic community as well to that effort. Well, I think we are out of time.
We are out of time. I wanted to just give our alumni participants an opportunity, since we're so short on time. We otherwise would have carved out some time to talk about this, but I see in the chat, our colleague Sarah Duggan has asked, what can non-lawyers do to help, given how much discretion there is in the government process? I know we had been talking before we went live about ways in which pro bono needs can be met. So I just wanted to encourage the three of you, if there's a link or anything that you might want to share in the chat before we wrap up tonight, that might be of interest to our participants. If you don't know it off the top of your head, you can feel free to let me or Cathie Smith in development know, or for that matter, Professor Breston, and we can try to disseminate that to our community as well. Because I know that people, even if they're not aware of all of the intricacies, there is just a great interest from a humanitarian standpoint. So perfect. I see people doing that. Thank you, Cathie. So yes, we are out of time, and I just wanted to say thank you to Professor Breston for bringing this idea and this awesome group of alums together. Thank you, Cathie. Thank you, Madeline. Thank you, Joe, for bringing your experience and your expertise. As Stacy said, it makes us so proud of our graduates, and in particular of our clinic. And thank you to Kate and all of the folks who've organized these behind the scenes. Have a great evening.
Thank you.